the actual purported final judgment from the circuit court. Convince me why that is actually a final judgment, just because it sort of substituted the word "I grant judgment" as opposed to granting the motion for summary judgment. That's the first part.
Okay.
And then the second part is this, assuming that it is a final judgment as to count one, does that conclude all the litigation, or are there still outstanding claims here? I mean, are we under 9.030, or are we under 9.110? You know, what's the jurisdictional basis here?
Your Honor, having received that inquiry from the court, I proceeded to go back through the case and do some additional research with regard to the appeal. And in this matter, there was pending at the time of the motion for summary judgment, the amended complaint that had been filed, the second amended complaint that had been filed on behalf of Lipsey Real Estate and Holdings. The court in that motion for summary judgment stated that the second amended counterclaim in essence was invalid because it was not filed within the 20-day time frame or the additional time frame that was granted by the motion for extension. That ultimate ruling never came about on the counterclaim, the second amended counterclaim, until May 31, 2019. The initial appeal in this case was filed long before that. This court remanded the matter back to the lower court to issue a final judgment. That final judgment was issued on June 12, 2019, which was clearly after the court had resolved the issue of the second amended counterclaim. However, I note in the record on appeal, as well as the record in the court file, on May 10th, 2019, Lipsey Real Estate and Holdings had filed a motion for leave to file fifth amended complaint. That motion has never been ruled upon, and that motion has never been resolved in the lower court. The motion itself contains an amended counterclaim, which has 4 counts in it. And those 4 counts, if you will.
Wasn't that the subject of a previous appeal, though?
No. The dismissal of the previous counterclaim that was dismissed on May 31, 2019, yes, ma'am, that was the subject of a previous appeal, at which time the court per curiam affirmed. However, it is the fifth amendment, and that was a second amended complaint. During that interim between the dismissal of the second amended complaint, Lipsey Real Estate and Holdings had filed a third amended complaint and a fourth amended complaint seeking to add additional third-party defendants, which was denied by the court. And then the court then after that, on May 31, 2019, ruled on the second amended complaint and determined that the second amended complaint was, quote unquote, invalid because it had not been filed within the time frame as specified by the court.
Okay, so in your view, there is still judicial action that needs to be taken in the trial court?
I believe that there are, yes, there is an additional action, which is the fifth amended complaint for which a motion.
Okay, then why should we not dismiss this appeal for lack of jurisdiction?
I believe that that may very well be appropriate, Your Honor, under the circumstances, because my further research indicated as to whether or not this appeal could be considered finalized would be whether or not, A, the other motions that were filed, the second amended complaint, what contained permissive versus compulsory. My research tells me that you could very well do an appeal where the counterclaim is permissive, the slander of title action is a permissive counterclaim, so therefore under that. However, under the fraud claim and under the other claims, they were so, as the court stated in another, not this court, but another court, if they are intertwined, then it would be inappropriate for an appeal to be formulated. In all candor, Your Honor, I mean, I did this research on the premise that I honestly believe that the matter was appropriate for the appeal. However, in looking back, what I see and into the case law that you asked me to be prepared to argue, then it is, I believe that the appeal is probably premature.
Okay. Thank you, Mr. Lifsey. I'll wait to see what your colleague has to say on the matter, but please continue with your argument.
Oh, okay. All right. Well, going on to the argument, Your Honor, with that in mind, what we're here on today is a summary judgment that was granted by Judge Huey on a renewed summary judgment. Now, interestingly enough, this case is an abrogation since the very beginning. And the abrogation being that it was never authorized to be filed by the client as against Lifsey Real Estate and Holdings. The client was Mr. Rako, who was the president of the association. He specifically stated in deposition that he did not authorize the filing of this complaint. So the question is, why are we here in the first place? Mr. Rako, who is the client and who, based upon my understanding of the Florida bar rules, is that we as attorneys are compelled to comply with the requests of our client. The attorneys did not. Moving on, however, that it was not authorized, we come to an issue of what actually occurred. If you want to go back to 2014, when the case was filed in December of 2014, the subsequent records that have been created in this situation by the attorney's law firm, and these are the records that have been presented to the court, and these are the records that Judge Huey asked be reevaluated, shows that on December the 14th of 2014, when this cause of action was filed against Lifsey Real Estate and Holdings, Lifsey Real Estate and Holdings was not only not in default of not having paid the assessments, and the reason for that is because the recalculation ordered by Judge Huey said, no, you only are allowed to sue for the assessments. You cannot sue for the attorney's fees or how you've applied this if you've misapplied it, which is what in essence was done. And that was the reason for the reaccounting, that on December the 14th, Lifsey, and for 4 months thereafter, had a positive credit balance. So if you want to go back to the original complaint, and the original complaint alleges, as does the amended complaints, that the default was in 2013 as of December 2013, there exists, and the deposition of Bona Larson, who is the quote unquote specialist in this case, testified that as of May, Lifsey was current, May 2014. Mind you that the claim of lien that was filed in this cause in September was determined to be void because of the fact that it was not appropriately signed by Mr. Rako. So then we come to the causes of action that have occurred. The original complaint, even though the claim of lien and the original complaint alleged $711 as owed plus some interest, what they allege is that it's all based upon the claim of lien, which was for almost $2,500. In the proceedings, I consistently asked for, how did you arrive at these dollar figures? Well, that brings us to the proposition that the dollar figures and the information that was relied upon for the original complaint of $711, the amended complaint for $13,000, another amended complaint in December of 16 for $14,000, and finally, the second amended complaint demanding $18,000 was all based upon the accountings of the law firm. not based upon the accountings of the client. So what do we have? We have the law firm creating evidence for the purposes of continuous litigation, wherein they dictate to the client how the money is to be applied, because they are applying the funds, having received the funds, and then they're telling the client, well, we're going to apply it to attorney's fees, we're going to apply it to interest, we're going to apply it to late fees, and then, by the way, this is how much you get back. You take that money and you apply it to the, telling the client, you apply that to the assessments. Well, that's not what Judge Huey ultimately ruled. And what Judge Huey ultimately ruled is that that is an inappropriate allocation of the funds, and that there was never a demand made upon Reyna, who was brought in on the amended complaint on December of 2016, alleging that it was $14,000 due, and then for which a second claim of lien, having the first having been abandoned, if you will, or removed and released by the plaintiff in this cause, then asking from her for $18,000. It ultimately ended up at the end of the case that the matter that as it was offered, there ends up $1,700, which is based upon the accountings of the law firm. But these accountings are not verified. They are not admissible summary judgment evidence. And Judge Huey, unfortunately, during these proceedings, stepped away from his position of impartiality to aid and assist the plaintiffs in this cause. And for
Make
that
some
reason,
pretty serious accusations
yes, ma'am, it is.
in your brief, Mr. Livesey.
And I don't make them lightly, because of the fact that, if you will, the first one is that he advised counsel to acquire an affidavit in order to clarify a release. The release itself was clear and unequivocal. There was no pleading filed at that point in time that said that there was a question with regard to what this release did. However, Judge Huey said and ordered them to file an affidavit to clarify. Then we get into the situation of, in the Reyna case, Judge Huey assists counsel by telling him, what you need to do is you need to go back and you need to give me a reaccounting, and you need to take out the attorney's fees, you need to take out the interest, you need to take out the late fees, and tell me what Miss Reyna owes. Well, when they did that, not only did they not follow the instructions of the court, but they computed that amount based upon not only what Reyna would have owed, but what Livesey owed, if Livesey owed anything. But the problem with this case is you're going to a final summary, you're going to a renewed summary judgment with knowing that there was no default when you filed the case. Why are we in a default issue and the court did not rule and did not find a default? And that's got to be, in essence, one of the essential elements, as well as the condition precedent, that you make a demand, as is required by statute, for the amount due. Well, the amount due that was demanded of me always included what they wanted as to the application of the payments they had applied to attorney's fees and costs, which Judge Huey said, you can't do that. They never made a demand beginning in 2013, 2014 of Livesey Real Estate and Holdings of the assessments because of the misappropriation and the misapplication of the funds. Had
Excuse
they
me,
applied,
Mr. Livesey, if you'd like to reserve a little bit of time for rebuttal, you have about 4 minutes left.
I'm just make two other, yes, ma'am. I want to reserve 3 minutes if that's fine.
Okay, all right,
Okay.
sure.
I want to go to the issues of there has not been any avoidance. This summary judgment is inappropriate because there's not been an avoidance of the affirmative defenses that Livesey did file that were not struck by the court. In fact, there is no mention, there is no pleading whatsoever. That's in accordance with the SAR case. The amount due which it's impossible to determine what amount is in fact due because Judge Huey doesn't say so. And I filed a motion for rehearing specifically saying, would you please tell me what amount is due? He just says it was paid during the pendency of the litigation. With that, I'll reserve the rest of my time.
All right, thank you, sir. All right, Mr. Ellis or Mr. Davis?
Yes, Your Honor.
And would you start with the jurisdictional issue, please?
I can, Your Honor. We believe that it is a final order that is on appeal, and this court does have jurisdiction because all of the causes of action the plaintiff has filed in its complaint, 2 counts, have been resolved. There is nothing left for the trial court to do. The appellate court previously dealt with Mr. Lifsey's counterclaims in case number 19-2524, where per curiam affirmance was entered in May 15th, 2020, dealing with that side of the pleadings. The only thing remaining at this point is an evidentiary hearing on the amount of attorney's fees and costs to be awarded to the plaintiff as entitlement has already been found. And I believe that we have a final order because there is a separate litigation that was filed by Mr. Lifsey on behalf of Lifsey Real Estate and Holdings, dealing with the issues he raised in his counterclaims. So that is pending in the Hillsborough Circuit Court as we conduct this appeal. There's nothing left for the trial court.
And counsel, I don't mean to interrupt you, but that action is a separate action with a separate case number, has not been consolidated or in any way joined to this one?
That's correct, Your Honor. Separate action, separate case number. Now, we did just have a hearing before the trial court judge in that case.
Is the trial court judge the same as a Judge Huey again?
It is a separate judge. However,
Okay.
there is going to be a transfer back to Judge Huey that should be entered soon based on our hearing the last couple of days we had in that matter. But again, separate action was filed. Everything in this case that was before Judge Huey was resolved by the entry of the judgment on count 1 of the plaintiff's complaint. So I believe we do have finality for our purposes, and this court has jurisdiction to review that order. And Your Honors, responding to the issues raised by my colleague, Mr. Lifsey, this case really boils down to a plain condominium assessment collection case, where during the course of the litigation, Lifsey Real Estate and Holdings realized that they failed to pay one or more of the delinquent assessments the association filed suit on, that both Lifsey and their co-defendant, Susan Reyna, then paid those amounts, leading to the association requesting summary judgment based on those payments. At the summary judgment hearing, which spanned 2 days in front of the trial court correctly recognized that there did not remain any more delinquent amounts to be awarded to the association, which led to the judgment on appeal. And we believe that was the correct result. Here, the appellate—
The balance between the $1,700 paid and the $18,000 claimed is attorney's fees, penalties, interest, and all that?
Yes, Your Honor, it included the attorney's fees, interest, and the late fees, but it also included amounts which accrued monthly from December 2013 through the date when the co-defendant Reyna obtained title to the property, which was on July 20th, 2016. So at a monthly assessment, it does continue to accrue fairly quickly. That was the amount that the second amended complaint that the association is proceeding on requested. And that is the amount that when the calculations were submitted to the trial court and the payments were factored in as required by section 718.116, which is first to the interest, then the late fees, then the attorney's fees and costs, and then to the delinquent assessment. All that remained was an amount of $1,776.85. That is the amount that the co-defendant paid without reservation which then led to no other delinquent amounts to be awarded to the association, which is specifically reflected in the final judgment. Now, to get to this final judgment, the association filed, as part of its summary judgment evidence, affidavits of an officer of the association, which attested to the amounts that were due from LIFSI, as well as the property ledger, which was attached unauthenticated by the president of the association. It indicated that the association referred the matter after it had sent several notices to LIFSI for collections to our office. The second affidavit which was included was an affidavit of Ms. Larson, a specialist at Shoemaker, attesting to the payments that were received from both LIFSI and RENA and authenticating all of the copies of the canceled checks which were attached to the affidavit. It then provided the summary which was used on argument just to display the calculations and what we believe the damages should be. That summary was not disputed by either LIFSI or RENA, which led to the judgment being entered by the court. LIFSI had the opportunity to provide his own calculations. He filed several responses to the summary judgment motion. He failed to do so. And I believe that's important because here the appellant has the burden to show that the trial court committed reversible error. And we believe LIFSI's failed to show that the trial court committed reversible error in entering this judgment. It simply recognized that during the course of more than 3 years of litigation, after numerous discovery requests, that the amounts were delinquent and that they were paid by the defendants. The only thing remaining to be determined is entitlement and an amount of attorney's fees and costs, which is ancillary to our complaint. We relied on the fact that the payments amounted to confessions of judgment by the defendants. And that is based on the Payne case out of the 3rd DCA and the Augustine case out of the 3rd DCA also. Those payments, when applied pursuant to Chapter 718.116, lead to your final amount, which is due. And again, these are not amounts that the association is making up or amounts that the law firm is making up. This is based solely on the authenticated account ledger from the association, displaying the dates and the amounts of each assessment, each monthly assessment, and applying it per statute to the accrued interest, late fees, attorney's fees, and costs. Now, in this case, the trial court required, when it dismissed count 2 of our complaint, which was the lien foreclosure complaint, that the association apply it in a slightly different manner to interest, late fees, and then the delinquent assessments, excluding out the attorney's fees and costs. That order, which was entered on count 2 of the association's complaint, later turned into a judgment, was not appealed by either party, and we believe is binding on the application. That is how we got to the $1,700 and some change that was ultimately paid by the co-defendant to end this matter. Your Honors, we've detailed in our brief each of the items which was submitted to the trial court at the summary judgment hearing and authenticated by affidavits of the officer or Ms. Larson. The association clearly provided competent, substantial, unrebutted evidence to support the summary judgment request, which Mr. LIFSI and his client did not present any issue, material fact preventing the court from entering judgment. And Your Honors, as to the question of the release, Mr. LIFSI did file on behalf of his client some odd 25 affirmative defenses, the majority of which related to count 2, a lien foreclosure complaint, which did not at all involve LIFSI, solely involved the co-defendant RENA. Those affirmative defenses were various forms of conditions precedent, notices of release, or payment. Those affirmative defenses were refuted by the evidence submitted by the association at the summary judgment hearing, or shown to be legally insufficient. Specifically, the order which dismissed count 2, the lien foreclosure complaint, found that the personal obligation of Lifsey and Reyna was not determined by that order, that the claim of lien and the release did not release either's personal obligation. And that's a conclusion of law, which is reflected in the order itself and the record on appeal. So I don't believe the affirmative defenses, as my colleague states, were not addressed at the summary judgment hearing. Finally, I believe there was some question as to the impartiality of the trial court judge. And this was an issue that was also dealt with by an extraordinary writ filed by Mr. Lifsey on behalf of his client, where the court denied it. The motion for disqualification came on December 31st, 2019. The rule requires that you file within 10 days the basis for your request for disqualification. That would lead to only the matters which occurred at the December 19th hearing to be ripe for a motion for disqualification. The majority of what Mr. Lifsey, I believe in his brief, complains of does not address items that occurred at the hearing. It addresses items that occurred in the 2015 and 2016 hearings on evidentiary matters and discovery matters. Those matters were not preserved by Mr. Lifsey. So I believe the trial court correctly denied that basis procedurally on the motion for disqualification. Substantively, the remainder of the items address either adverse rulings by the court or comments from the bench indicating mental impressions the court has at certain hearings. And those cannot form the basis of a disqualification. And that's under the Gregory v. State case we cite to, and then the Pinkerton case out of the 5th DCA. With those being the remaining bases, we believe the trial court correctly denied, both procedurally and substantively, the motion for disqualification. And Your Honors, I don't want to belabor the point. I'm pleased to answer any questions you may have regarding our specific arguments in our answer brief. And if not, then I would yield the remainder of my time.
Okay, thank you, sir. Thank you. Mr. Lifsey, you've got
Thank you.
about a minute.
1 minute? Okay, thank you.
Well, between 1 and 2. I'll give you 2. How's that?
Thank you, Your Honor. Your Honor, first of all, the summary judgment that was initially denied by the court all had these affidavits, of which counsel refers to as the $18,000 affidavits. This is not the affidavit that the court relied upon in the renewed motion for summary judgment. What the court relied, and these were not amounts that were in fact due. That's the problem with this case, is that those records, if the court looks at the motion for summary judgment, the first one that was denied by the court, at the same time it entered the Reyna ruling, finding that there had never been an accurate demand, those dollar figures are the dollar figures that are sworn to by Larson and by the president of the association, and says these monies are due based upon our records. Well, if those are the monies that are due of the $18,000 that is based upon the official records of the association, how can you now come down to a court to a renewed motion for summary judgment, allege those affidavits, which are directly contrary to this filing? And that, by the way, this is just a filing by Bona Larson. It's not an affidavit. It is not sworn to of the amount that was recounted at the instruction of the court. Now the court has instructed them what to do to prepare the evidence in order that the court can rule. That in and of itself goes beyond the situation of the impartiality of the court. And then in fact rules that this money was paid. Well, we still get to the issue of when is the default that has occurred here. Mr. Davis wants to argue that the default occurred during the pendency of the litigation. Well, that's not the theory of when you file a lawsuit. You file a lawsuit when there is a default. There is no default, and there was no default in December of 2014. If there was a mispayment, fine, there's a mispayment. But that is in 2015 or 2016, not back as to when they filed the litigation, nor as to when they allege that the default occurred, which was back in as of November 2013. I apologize.
Okay, Mr. Lissy, you're at the end of your time,
Okay.
sir.
Thank
Thank you. You want to just wrap up real quick? Go ahead.
Yes, Your Honor. We have asked for that this court, based upon the walk-off in American Home, and the bad faith and the unclean hands of the parties of the plaintiff in this action, that this court dismiss this cause because of the fact the unclean hands they were never authorized to file a lawsuit.
Okay, sir. Thank you all. It's 11:50. We are going to take a 5-minute break. We'll be back at 11:55 to hear our last case on today's docket.